thank you to the Liberty Forum for the opportunity to speak again about property rights. Last year, about property rights generally. This year, I'd like to focus in particular on how our constitutional liberties, with a focus on private property rights, are affected when we are in a quote-unquote emergency. And to that end, I have prepared a PowerPoint to help guide the presentation, and assuming that I don't make any grave errors in there we go in presentation. This evening I'd like to focus on the general law, you could call it, of emergencies under the Constitution, or the constitutional law of emergencies. And then I'd like to focus on how that law has been applied to the most important protections of private property rights in our federal Constitution, those being the right against impairment of contracts, the right against deprivations of private property without due process of law, and the right against having your property taken without just compensation. And then I'll close the presentation with a brief discussion of a case that Pacific Legal Foundation filed just last month, challenging one of the more significant intrusions on private property rights here in California that has been effected at the state level because of attempts to respond to the coronavirus pandemic. And then, of course, at the very end of the presentation, more than happy to answer any of your questions about these issues or related constitutional issues. So to get things started off, the law of emergencies under the Constitution dates in some respects back to the case of Jacobson versus Massachusetts, a case over 100 years ago, which concerned an epidemic in Cambridge, Massachusetts, an epidemic of smallpox. And the issue was Mr. Jacobson had been previously vaccinated and had had a bad experience. And so he objected to the local Board of Health's attempt to force him to be vaccinated. He argued that that deprived him of his liberty without due process of law under the 5th and 14th Amendments to the federal Constitution. And in rejecting Mr. Jacobson's challenge, the Supreme Court articulated what I think you'll find to be a really critical concept as we discuss later this evening about constitutional liberties in an emergency, a really critical concept, and that is the quote-unquote police power. Now, you'll oftentimes hear in discussions of constitutional law this doctrine of the police power used generally. That is, that government has generally the power to protect the public health, health, safety, and welfare. That's not quite what the court is getting at here or what we'll be talking about later. There's a particular application of this quote-unquote police power, which is used to justify certain government action in a quote-unquote emergency. And essentially what the Supreme Court has said is that in an emergency, the state may exercise the police power to do things that otherwise would not be constitutionally permissible outside of an emergency. And in rejecting the challenge to the vaccination requirement in Jacobson, the Supreme Court basically said that the courts will not second guess the factual underpinnings of a declaration of emergency unless it's clearly irrational or unless it's clearly a pretext, in the sense of there is no scientific justification for what's being done, and yet it's obviously a pretext for some other improper purpose. Barring that, the courts are not going to second guess the underlying declaration of an emergency that gives rise to the power of the government to exercise its emergency powers. Moreover, the court articulated a principle of pretty significant deference to legislative action in an emergency. Deference not just to the facts, but also a type of legal deference. And you'll see that really articulated in the second quote there on the slide. That the court's going to say that, well, in an emergency, it's not enough that we think that the legislature has acted unconstitutionally. it has to act really unconstitutionally before we want to second guess. So you have both a combined factual deference and you have a legal deference that the courts are going to employ whenever there are challenges to government action in an emergency. Now, this is not to say that the court said that there's no judicial review. The court actually went on to say that, well, if there were really strong evidence, for example, here, that if Mr. Jacobson had been vaccinated, he would have suffered a serious physical or other injury, then the courts in a proper case can give relief. But that evidence wasn't adduced in that case, and more generally, this principle of deference to government action in an emergency is one that you'll see repeated in the cases in many different contexts, including contexts more directly relevant to private property rights. Which leads us to sort of the first emergency powers case of the 20th century that dealt specifically with private property rights, and that's the Block versus Hirsch case. This is a case that came out of the aftermath of World War I. At the conclusion of World War I, there was a pretty significant housing shortage in this country, and that housing shortage gave birth to really the first attempt of government to enact rent control and other types of eviction moratoriums to protect existing fee holders, to protect existing tenants, and as we see even now with the coronavirus pandemic, very similar things being done. Anyway, in the Block case, Congress passed a law that authorized the creation of a rent control board for the District of Columbia. And pursuant to this law, the District of Columbia Rent Control Board issued a regulation that said that those tenants who were currently in their leases, in their apartments, had the right to hold over for at least a year, even if their lease agreement with their landlord otherwise gave the landlord the right to terminate the lease. The landlord sued to overturn that, and the Supreme Court, in an famous opinion written by Justice Holmes, said that, again, because this is an emergency, in this case not a pandemic, but in this case an emergency of lack of housing, the courts are going to be particularly deferential to how the legislature responds to remedying that emergency. Key to the court's upholding of the ordinance or the regulation in the Hirsch case that gave the tenant the right to hold over, notwithstanding the lease terms to the contrary, was, and this is an important fact I think to keep in mind as we talk a little bit later about the constitutionality of current efforts to limit the rights of landlords in response to the coronavirus pandemic. One of the important facts for the court here was that the lessee, the apartment dweller, even though he could hold over, still had to keep paying rent. And so the court was convinced that this is not an unreasonable regulation. It's only a temporary provision. It's limited in time. It's limited to the particular emergency of a war-induced housing shortage. And the equities are fairly balanced because although the landlord can't retain possession of the leasehold, he does receive some compensation while the moratorium on the lease termination remains in effect. Now, the Block case, it's important to bear in mind, concerned the protection in the Fifth Amendment against deprivations of private property without due process of law. The next case that I'd like to address concerns a special protection in the Constitution that applies only to the states, and that's one reason why it wasn't raised in the Block case. And that protection is the provision in the original Constitution that forbids the states from impairing the obligation of contracts. Now, this was an incredibly important provision in the original Constitution, one that has its origin in the Northwest Ordinance of 1787. So important, if you recall, that it was included in the original Constitution. It wasn't even added in the Bill of Rights. It preceded the Bill of Rights. And it was a protection that the founders thought was particularly important. They were familiar at the time, during the Revolution and right after the Revolution, of extreme economic disruption. And there were many attempts in state legislatures to pass legislation to relieve debtors of their obligations. And as you can imagine, this caused not only significant economic turmoil, but also significant controversy. To prevent that from happening, one of the few limitations on state action in the original federal constitution was this provision prohibiting the impairment of the obligation of contracts. For most of the 19th century, the Supreme Court interpreted that provision pretty strongly, especially with respect to attempts from states to try and overturn or amend existing contracts among private parties. But that tradition then hit into a significant obstacle known as the Great Depression. In the Home Building and Loan Association versus Blaisdell case from 1934, the Supreme Court reviewed a mortgage moratorium law that was enacted by the Minnesota legislature. Under this law, those who had mortgages, who had defaulted on the mortgage, could apply to a court to have the court extend the period of redemption in order to reclaim the mortgaged property. Under pre-existing Minnesota law, that was about 30 days. But under the law that was enacted by the Minnesota legislature in 1933, that was extended to up to 2 years. Now, the justification for this law was that the Great Depression had caused significant economic disarray and dislocation, that there were many people who were put in the pinch, who couldn't pay their mortgage, and the fear was that they would lose their property, become dispossessed, and you would have a significant social problem with people not having a place to live, not unlike many of the justifications used today for coronavirus-related measures. The law was challenged under this provision of the Constitution, that there were existing mortgage contracts. The mortgage contracts gave the banks, those holding the mortgage, the right to repossess, the right to foreclose, and the right to sell after the 30-day redemption period had expired. The law clearly was designed to frustrate that provision of existing contracts by extending up to 2 years that period of redemption. The Supreme Court, in a very famous decision and a very contested decision, ruled 5-4 that the Minnesota law was not an impairment of the obligation of contracts. And you could say, again, one of the essential underpinnings of the majority's decision is, again, this concept that we saw previously discussed in the Jacobson case and also in the Block v. Hirsch case, the concept of the police power. And here, the Supreme Court did something you could say was a bit of an interpretive sleight of hand. The court said, well, it's true that the states can impair contracts, but it's also true that when you enter into a contract, that contract assumes the state of the law in which you enter into the contract. And it is assumed that the state always has the power to act in an emergency, that the emergency doesn't create the power, but the existence of the emergency then gives rise to an otherwise latent power. And this principle is sort of implied in the nature of government, and therefore it's essentially read into all contracts made. And so the court from that point really didn't have a very difficult time concluding that there wasn't an impairment of contract here. Now, the court did go on to say that it's not simply enough that an action is done pursuant to a purported emergency, that is not in and of itself reason to immunize a statute from attack under the impairment of contracts clause in the Constitution. The court went on to articulate a few things that were peculiar to the Minnesota law that, in its view, made the equities somewhat reasonable. One big, I think, factor that the court highlighted is that although the period of redemption was extended for 2 years, during this period, the original homeowner or the mortgagor still had obligations to the bank, still had obligations to the people who held the original mortgage, including the obligation to pay the reasonable rental value or the reasonable monthly income value of the property that they were still in possession of during the redemption period. Moreover, there wasn't any forgiveness of either the underlying obligation or of any taxes or fees or late charges. It was really essentially a statute limited to keeping people in possession and also giving them the right, an extended right to redeem their property. The court really emphasized that those things made this, on balance, a just and reasonable response to the economic emergency, that therefore made the law consistent with the constitutional prohibition against the impairment of the obligation of contracts. Now, since the Blaisdell case, there have been about a half dozen or so Supreme Court cases that have addressed the same provision. And some cases have actually, in fact, held that laws have violated the impairment of contracts clause. In fact, the most recent time the Supreme Court held that way was in the late 1970s, and it concerned another statute from Minnesota, this one that tried to tinker with the obligations of companies that had pension agreements with their employees and when those pension agreements vested. So it's not to say that this clause is a dead letter, but it's certainly fair to say that in order to show a violation of the impairment of contracts, it's not enough simply to show that your contract is being impaired. You really do have to show a significant impact, and you have to show that there isn't a reasonable relationship between the emergency that's been declared and the burdens that are being imposed connected with the legislation that impairs the contract. All right, so far we've discussed due process of law. We've discussed impairment of the obligation of contracts. What we haven't discussed yet, though, is what some might call the sort of preeminent protection of private property rights in the Constitution, and that is the provision that forbids the state or the government generally from taking private property without the payment of just compensation, the takings clause, which applies both to the federal government and to the states. Unfortunately, this clause perhaps has taken the biggest hit over the last century and more when it comes to the private property right protections of the Constitution in an emergency. And you'll see on the slide there a case not from the US Supreme Court, one from the California Court of Appeal, but one that really exemplifies kind of the problem. You see this in a lot of the cases dealing with alleged takings of private property rights in an emergency. In the Farmers Exchange case, the issue was back in the 1980s, we had a Mediterranean fruit fly problem in California. In response to that, there was aerial spraying of malathion to stamp out the pest. One of the unfortunate consequences of that spraying was that a lot of cars parked on streets where the spraying happened ended up having their paint jobs destroyed. And so there were a lot of claims on insurance companies to pay for the paint damage, and so the insurance companies then brought an action against the state of California asking for compensation. Now here, the court really did short work with the constitutional challenge, and again, really emphasizing the importance of this concept for understanding how our rights are diluted in an emergency. The court relied upon this concept of the police power. Not, again, the general police power, but the specific police power that arises when there is an emergency. That essentially, what the court says in the Medfly case, in which the courts typically say in these takings cases, is that one doesn't have a right to the taking, one doesn't have a right to just compensation when one's property is taken in an emergency, because the emergency itself is the full sort of justification for the taking, such that just compensation is no longer required. The quintessential example is where you have, say, a conflagration that threatens to consume a town. And in order to save part of the town, the fire department has to create a fire break that involves destroying a few of the houses. If one of those homes is your home, well, the courts will say no compensation, because that was a necessary destruction in order to preserve the general welfare. The same thing in the Medfly case here, and the same thing generally in these takings cases, such that takings claims in an emergency are very challenging. Now, of course, there's always the possibility that one can contest the factual basis of the emergency, but as we saw from the Jacobson case, the vaccination case from Cambridge, Massachusetts, the courts generally are going to be very indulgent when it comes to second-guessing the factual underpinnings of a legislative declaration of an emergency. Now, in part, I think because of this somewhat checkered history, I wanted to conclude this part of the presentation with what I think is perhaps one of the finest dissents of the 20th century, written by a justice that oftentimes isn't much recognized today, but who was really on the forefront in trying to protect private property rights and other liberties, especially during the New Deal era, Justice George Sutherland. And that's a quote there from the Blaisdell decision, again, the decision that upheld the Minnesota law extending the redemption period for mortgages. What he says is absolutely right, that if we feel like we have to relax our liberties when there is a great controversy or emergency, then that really is undercutting essentially the very purpose of the Constitution. We don't need the Constitution if we're only going to abide by majority rule, but it's precisely when the majority may be misled by emotion or passion that we especially want the protection of minority rights. And if we're not going to do that in an emergency, well, we might as well not do it at all. In part, I think, because the courts have not been real zealous in protecting private property rights in emergency, state legislatures have tried to provide some legislative backstops. And of course, that's perfectly permissible. The courts will say, constitutionally, this is not required. Okay, but that doesn't stop the legislatures from providing statutory protections. And I think you see some of that in the California Emergency Services Act. Now, this is probably the most important statute that we have in California with respect to understanding what's been going on over the last several months. This law, passed in 1970, is the cornerstone of the governor's ability to do what he's been doing. You see on the slide there what I think are the three most important provisions of the statute that provide, among other things, essentially invest the full power of the state in the governor, so long as the emergency that has been declared is continuing. Now, in addition to vesting sort of the full police power in the governor, the statute also gives the governor the power to suspend essentially any administrative regulation and many statutes. But it also provides, and this is relevant to our discussion of the statutory rights that maybe the courts aren't providing, but maybe the legislature can provide in their stead, provide some protections. And perhaps the most significant one is that the statute says that if the governor's actions result in the commandeering or utilizing of private property or personnel, reasonable compensation must be paid therefor. But that is an obligation, regardless of what the Constitution requires. That's an obligation by statute that the state has taken upon itself. An example of where that might come into play, where even the governor was acknowledging that it would be required, is part of the emergency coronavirus response to house a homeless or other persons who don't have housing in hotels and motels. That sort of commandeering of private property for that purpose, that even the state would acknowledge, would trigger this obligation to pay reasonable compensation. And of course, you see there particular protections with respect to the right to bear arms. How are these rights playing out in litigation? Just 3 or 4 weeks ago, Pacific Legal Foundation filed a lawsuit in California Superior Court in Bakersfield challenging one of these state efforts to use the coronavirus emergency to impinge the private property rights of Californians. The lawsuit, called Christensen versus California Judicial Council, is a lawsuit that challenges what's called Emergency Rule 1. And to give a little background here, in California, the California judiciary is formed principally by our courts, but there's also a separate administrative agency that's considered a judicial branch agency called the California Judicial Council. And this council is tasked under the state constitution with coming up with most of the court rules that govern procedure in California courts. In March, one of the first things that Governor Newsom did was to issue an emergency order that gave those tenants who could not pay rent a temporary reprieve against an unlawful detainer action from a landlord. That is, an action brought in state court by the landlord to evict a tenant for non-payment of rent or for otherwise violating the terms of a lease. Now, that executive order expired at the end of May, and those who wanted to avail themselves of that executive order had to prove that they could not pay rent because of a COVID-related illness or because of a mitigation-related economic injury, and had to adduce evidence of that to the landlord and to the court. But that expired at the end of May. At the same time, the governor said, well, maybe we need something else done. And so he issued another executive order, this one to the Judicial Council. And that executive order said, well, if you, Judicial Council, want to come up with something better, go right ahead. And I will deem waived any statute that otherwise would preclude your efforts to come up with something better. And so, heeding the governor's invitation, in early April, the Judicial Council issued a set of 11 quote-unquote emergency rules. And the first rule, Emergency 1, puts an indefinite stay on the right of landlords to bring unlawful detainer actions. This indefinite stay, unlike the original stay that the governor's first order implemented, this indefinite stay has no evidentiary requirement about being unable to pay rent or otherwise being unable to meet the terms of a lease because of COVID-related problems. Rather, it's just a blanket stay. Doesn't matter what the reason is. No landlord, except in very limited circumstances, has the right to bring an action in California court to evict a tenant who has failed to pay rent for any reason, who is violating any other provision of the lease, except for very limited circumstances. So our lawsuit that we filed challenges Emergency Rule 1 on constitutional grounds, not federal constitutional grounds, because as you can surmise from our discussion earlier in the presentation, the federal constitutional law is not that great. We're focusing in this lawsuit on state constitutional provisions, in particular, the provision of our state constitution that enshrines the doctrine of separation of powers. This is a doctrine, of course, that's also in the federal constitution. In our state constitution, what it means is that the legislative power is given to the legislature. The executive power is given to the executive, in particular to the governor, and the judicial power is given to the judiciary as well as to the Judicial Council. One power cannot be exercised by another branch of government. That's the key provision. Here, however, with Emergency Rule 1, our argument is that, well, wait a second. You have the Judicial Council issuing this stay on unlawful detainers. That's essentially a legislative policy choice. In doing that, the Judicial Council said, yes, we know that we're contradicting a number of statutes that say that landlords have the right to retain possession of their leasehold if the tenant violates the lease. Sure, we're contradicting statutes that say that this is an important right that should be given solicitude in the court's docket that's entitled to speedy resolution. Of course, we're contradicting those things, but the governor says we can, and we're making that legislative judgment because, after all, the legislature in April, it's not in session. And this is an important issue that has to be addressed right away. So we're going to step into the breach and do something. That, we believe, is a clear violation of the separation of powers. But it's also a violation, to some extent, of what the governor is supposed to be able to do under the Emergency Services Act. If you recall, one of the provisions does give the governor the power to suspend statutes. But if you look closely at the Emergency Services Act, it doesn't say the governor can suspend any and all statutes. It says the governor may only suspend, quote unquote, regulatory statutes. What does that mean? That means he can't suspend substantive statutes. That is, statutes that codify our existing rights and liberties. Of course, one of those rights is the right to private property, and as a landlord, it's the right to reclaim your leasehold if the tenant is violating the terms of your lease. And so in that respect, any attempt that the governor might argue to say, well, I just simply suspended all the statutes that prevent the Judicial Council from acting, that in and of itself would exceed his authority. We hope by this lawsuit both not only to vindicate the private property rights of landlords, but we hope also to create some good precedent in California. Because although the Emergency Services Act, which again is sort of the foundational statute that has purportedly justified all that the state has done since March, that statute, although enacted 50 years ago, has almost no interpretive history. There's hardly any legislative history. There's hardly any case law. There's hardly any discussion in the law review literature as to what these provisions authorize, by the same token as to what the rights guaranteed in the statute extend to. this lawsuit, we hope, will be not only one of the first to establish those precedents, but also to establish important precedents that the rights of private property and constitutional liberties generally are not subject to diminution just because there's an emergency. Again, underscoring what Justice Sutherland said in his dissent in the Blaisdell case, which I quoted earlier, that if the provisions of the Constitution aren't observed zealously in a time of an emergency, then there really is no point to having those provisions to begin with. The lawsuit that we filed, we expect the state to try to dismiss. The case will be litigated, I hope, in the next few months in trial court in Bakersfield, and we'll see where it goes from there. But that is just the first of several efforts that PLF is planning both in California and in other parts of the country in order to ensure that any response from the legislature or from the governor's office to any emergency is not only reasonable, but one that is appropriately guided by our constitutional liberties. So with that, I want to thank you very much again for the opportunity to present on, again, as last year on private property rights, but what a difference a year makes now in this difficult time of responding to a new novel threat, also at the same time trying to vindicate the same private property rights that have protected us for the last 200 plus years. So with that, I'll hand it back over to Jane or to Erica and or Keone, and I'm more than happy at this time to answer any questions you may have about those cases or about other constitutional issues.
So we have a few questions lined up, and I'm sure the responses will we'll get some more questions there as well. One of the early ones was someone's wondering if we as citizens, is there standing to suing for the destruction of public art like statues? Is that something that is, that's not pandemic, but it's, if we put sort of civil unrest and the pandemic in the same box, could you comment on that?
Yes. So a little background. Generally in state courts, especially in federal court, there is the doctrine of standing, which is a theory that if you want to sue in court, you have to have a particular type of interest. And especially in federal courts, just the interest that one might have as a citizen or as a taxpayer in ensuring that the law is abided by or that money is not improperly spent, that generally is not enough to justify one's case as a plaintiff. Now, state courts oftentimes are more generous in terms of standing. And in fact, in California, we have a very generous doctrine of what's called citizen standing. This is a principle that allows basically any citizen of the state to bring a lawsuit contending that the government is not following its clear obligations to act, or in the case of a prohibition, its clear obligation not to act. So it is, in theory, possible for just a citizen to bring an action, in this example, to protect public property. However, the doctrine is discretionary, meaning that the courts don't have to entertain a lawsuit by a citizen in such a circumstance. And frankly, given the very politicized nature of these acts of vandalism, I could very well see a court choosing not to exercise its discretion. However, in theory, yes, a citizen can bring a lawsuit in state court, at least, just based upon his or her status as a citizen of the state.
Okay, this next question deals with public education, another offshoot of the pandemic, and schools are being closed. Will they open or won't they, and in what format? And schools, of course, get a lot of their revenue from property taxes. Could a case be made that with the attenuation of that, is that an unjust taking, or because you're still paying your taxes, but it's not going to the schools, and the schools aren't opening?
Well, it certainly seems to me that if services are not being provided, then the money should be returned to the people. No question about it. Now, is that just a policy question, or could you fashion a legal claim around that? Just if you go back to one of the slides, we're talking about the takings in an emergency and how the police power is sort of a total exemption to just compensation liability. In a similar sense, the designation of something as a quote-unquote tax operates the same way, that whether you're in an emergency or not, the courts will say that if something is fairly characterized as a tax, then it is necessarily not a taking. Now, that doesn't mean, though, that there is no recourse at all. So, for example, in California, our state constitution has a pretty elaborate series of protections, of course, going back to Prop 13, but more recent propositions that do impose limitations on when and how general taxes, special assessments, and other things can be assessed by local or state governments. And typically, there is a supermajority voting requirement. Also, there is in some local government, quote unquote, exactions, when the local government wants to charge something as a condition for getting a building permit or other discretionary permit in order to generate revenue for some other project. There is actually a provision in state law that requires refunds if those monies are not spent in an appropriate fashion within a certain period of time, or the local government doesn't update accounts appropriately. And that's under a law called the Mitigation Fee Act. And so oftentimes school fees can be exacted from property owners under the aegis of that statute. So that is one avenue of recourse. And that's not specific to emergencies. That's just a general right of property owners, and one that I don't think would be relaxed just because there is an emergency. So that is one possibility. But again, that's a statutory remedy, not a constitutional one. And that is, if one of the themes I wanted to impart in the presentation today is that I think by and large we need to look to statutory or other procedural protections to vindicate our rights in an emergency in particular.
Okay, we have two questions related to what happened recently in St. Louis, Missouri, with those two individuals, of husband and wife, trying to protect their property. Is that a violation of the Second Amendment? And if not, why not?
That one I'm going to have to pass on, simply because although I certainly support the Second Amendment, I, as a lawyer, don't know very much about it. It's not one of the areas that PLF does a lot of litigation in. So I would not be able to.
Fair enough. Yeah, we've heard a lot now about California. How does California compare to other states in terms of emergency powers and limitations?
That's an excellent question. I mean, to some extent, you could say, well, it's kind of hard to judge because in, say, South Dakota or Wyoming, even if the governors can do certain things, they have a certain culture of private property rights and constitutional liberties that they're not even going to try to push the envelope. And so these legal issues don't arise, and kind of where they only do arise are in more liberal jurisdictions where, not surprisingly, the statutes are more liberally interpreted and enacted to authorize greater government power. I'll give you an example. There was a case in Oregon in which case, a number of churches had sued to overturn one of the Oregon governor's orders limiting when worship services could be held. And the Oregon trial court had ruled in favor of the churches, saying that the governor was not authorized to issue the particular order under that state's Emergency Services Act. And the Oregon Supreme Court just last month overturned that decision and said that no, of course, the governor can issue these orders indefinitely. We've seen similar things in Washington State. We have a case actually pending right now in Connecticut in which we represent nail salons who, as we know, are one of those unfavored, supposedly non-essential businesses that don't get to open, trying to vindicate their right to conduct business in a safe manner against the stay-at-home orders issued by the Connecticut governor. So I would say the short answer is that California is bad, but not frankly much worse than other states. Again, with the caveat that there are good states out there, but their elected officials have the sensible restraint to take into account the liberties and rights of their citizens and not test the issue, and so the issues won't be litigated.
That makes sense. You mentioned that there is the government can reimburse the owner for confiscation of property. Is there a time limit? Can it take years, decades, or is it done in a timely manner?
The statute says that basically you sort of go through the process you would for like a tort claim against the state. So if, a state official, runs you over while you're crossing the street, you can bring a tort claim against the state agency. There's a process where you file a claim. I don't think the process has been used that much. And so that's, one of the question marks is to, what if the state disputes the claim? How would you litigate that? Or even if the state doesn't dispute the claim, how long does it have to provide compensation? That's kind of a question mark. One thing that we've considered doing at Pacific Legal Foundation is testing, well, how far does that statutory right extend? So, for example, the governor has said, sure, if I require hotels to house homeless people, that is a commandeering of their property. All right. Well, what about landlords who are told that they can't evict their tenants, and the ostensible reason is the same, that we don't want, in the stay-at-home orders, we don't want people without places to live. Well, aren't effectively their properties being commandeered or utilized just as much as if the governor had actively said, we're going to house people in your property? So we thought maybe that could be a creative way of getting the courts to address how far that statutory right goes.
Getting back to your case in Bakersfield, what are the chances you think you might win? And if you don't, would you go further up the legal chain?
Well, I should mention we have two great clients. Our lead client, Peggy Christensen, she's a retiree in her 60s. She has just a single 8-unit apartment building. It's always in demand. There are a lot of people who need housing and who really want to rent from her. And she had one tenant who had a significant other come into the lease and then hold over, hasn't paid rent since before the coronavirus epidemic started. She can't get rid of the person. I'm hoping that with a good client like that, to show that this is not a question of big, bad corporate landlords against impoverished, good faith tenants, but rather it really is a case of individuals trying to vindicate their private property rights. I think we've got a decent chance. We are in perhaps the most conservative county in the one of the most conservative counties in the state. We're in Kevin McCarthy's district. Our particular trial court judge, it was appointed by Schwarzenegger. I think that as far as the California judiciary goes, we've got a decent shot in the trial court. Now, on appeal, who knows? but even the California Court of Appeal in Fresno, which would be the relevant court of appeal, is one of the more conservative ones as far as this state goes. So we've got a decent shot. But the reality is that if the rule was we can't bring a case if we think we probably are not going to win, that we wouldn't be bringing very many cases, because part of what we do at Pacific Legal Foundation is precisely to push the envelope. In part because for so long there was nobody defending private property rights and other liberties against government encroachment in courts throughout the country. So we have to push back. We have to understand that sometimes we're going to have some losses, but if we don't fight, then things will not get better, and we're not going to give up. And so this is the first effort. It may be successful, but whether or not it's successful, it's not going to be our last effort.
That's good to hear. I always find this fascinating. There are two questions, and they came in 2 minutes apart, and they're sort of two halves of a whole. One of our guests wants to know, are there any limits to an emergency? Can it be defined however the governor wants to? And secondly, how long can it last? Is that somewhat arbitrary? Are there any rules on the other side?
That is an excellent question. I mean, as you can imagine, the definition of an emergency is pretty broadly defined. And as we saw in the discussion of the constitutional case law of emergencies, the courts are pretty darn deferential to the governor or the legislature's assessment of the facts that give rise to the emergency. Now, how long it goes, that is an interesting question. One that really hasn't been tested very much, because as far as I know, past exercises of emergency declarations have been pretty targeted to local circumstances. One of the first things you have going on here too is that even if the pandemic is fully controlled, there still is a reason for the governor to keep the emergency declaration in place just to get federal funding. And so the question is, well, if that's the only reason, would that still hold up? One important point to raise too is that in the challenge that we filed against Emergency Rule 1, and one of our arguments as to why it's illegal is that on its face, the emergency rule expires 90 days after the emergency declaration goes away. So we argue that even if you otherwise think the emergency rule is fine, surely you can't justify the rule to stay in place 3 months longer than the actual emergency itself. So that might be one way in this case that we could test what one of the questioners mentioned as to how long can it last. But it kind of runs up against the general problem I mentioned earlier, that this statute, although it's been on the books for a half century, signed in fact by Governor Reagan, it's hard to say what it means because it hasn't received a whole lot of attention, frankly, because most of the times when it's been used, it's been for floods or forest fire, or traditional localized disasters that didn't create any controversy, totally unlike what we have now.
And that's a perfect segue. I was going to ask this question. I used the moderator's prerogative, a question of my own. You were going through your presentation, Damien, and you mentioned the California Emergency Services Act, and that was 1970. In my experience, usually these kinds of acts are reaction to something. Did something happen late in 69 or 1970, or because those 3 or 4 points, they're pretty broad of what the governor can do. There's not a lot of half-shoeing there.
That is an excellent question, and one that we're actually trying to research now. In fact, we've been researching in the state archives. It's been pretty slow going because of the coronavirus closures. They don't let people in, and they have to rely upon their researchers. But we've been researching that very question for the legislative history. We can't find anything in the cases. We can't find anything sort of just generally available to describe in the law reviews, for example. Where did this law come from? What were the antecedents? What was on the books before it existed? The literature is basically silent. And so we're hoping through the archival research we're doing that we can figure out a little bit more as to where it came. Sometimes you'll find that these state statutes are the result of templates that are sort of distributed among the states. So there'll be uniform acts that govern administrative procedure, or uniform acts governing contract law or torts or what have you. It may be something like that, but that's certainly something that we're trying to figure out.
Okay, this may be a little out of your purview as well, but one of our listeners has a question of once the COVID vaccine is here, does the state have the right to force you to take it? Not really unlike the Jacobson case that we were discussing. That was the first case in the presentation. You recall that was a smallpox outbreak, and the objector brought a due process challenge, and he lost, and he either had to be vaccinated or he had to pay a fine. Now, the court did say that if there were evidence that he would suffer significant harm, then it may very well violate his constitutional rights to be forced to be vaccinated. And of course, there's been a lot of vaccination law, a lot of cases litigated since then, and I'm not certainly not an expert on that. But from what I do know, I think there would be, depending upon what the argument would be for the harm in taking the vaccine, I think there would be a colorable constitutional argument. But that again is something that that has received a lot of attention, more in the due process context than in strict property rights context. Well, all over town, I'm sure the same is right. It's same in Sacramento. There's signs on the doors of businesses, maintain social distancing, you must wear a mask. What about the reverse of that? What if the businesses won't enforce that? Are they under some penalty? I guess they won't get their COVID-19 green check mark, but what if a business doesn't want to choose to enforce that?
Yes, I mean, certainly my understanding of how the health and safety code is being interpreted, that the businesses are subject to significant penalties for not abiding. Now, you could say, just from a purely libertarian perspective, even if we didn't have any laws about that a private property owner would be entitled to condition entrance onto his property as he or she wishes, so that say Whole Foods said, well, we're just going to have a policy that we want people to wear masks. Well, that's its prerogative as a property owner. But as far as state mandates, yes, my understanding is that there are significant violations. I will mention one other case that PLF was going to bring that actually we won even before we filed, a case coming out of Napa in which we represented an art gallery that was fully prepared to do full social distancing, masks, everything consistent with all of the recommended guidelines, and Napa County was sending cease and desist orders saying you can't open your art gallery, even though there were many other businesses in town that had the same or greater risks of infection. And we notified the county council the day before we were going to file our lawsuit and our TRO and preliminary injunction motion. And the county then immediately said, oh, well, actually, you've misinterpreted our county ordinance. We actually do consider the art gallery here to be an essential business, and so yes, you can proceed with your art gallery reopening, et cetera, et cetera. And if any of you are interested in learning more about that particular win, just go on our website, pacificlegal.org, and you can find out more about that. But yeah, generally speaking, I think if you are a property owner, a commercial, if you're in business, and you're thinking about challenging any of these restrictions, either being not considered an essential business or being required to adopt various protocols, I think the best chance of success is not contesting the underlying science supporting whatever measure, but rather making an inconsistent treatment argument. That was essentially what succeeded in the Napa art gallery case, and I think that is one that will resonate with some judges, that if you're going to impose these strict prohibitions, you have to be consistent, meaning that you can't say no to one business but then say yes to another, where the one that is allowed to operate actually presents a greater risk than the one that's not allowed to operate. Now, the courts aren't going to be real interested in real fine-tuned second guessing, but if you can show a pretty gross inconsistency, then I think that that there's a fair chance of success.
This next question is very basic and it's wonderful. Do citizens have the right to even challenge the existence of an emergency? The statistic that's quoted that here in Santa Clara County, less than 4% of the hospital beds are occupied by COVID patients, but businesses have shut down. That seems very unequal. Any comments about that? Can we say anything? How do you define emergency, Governor?
Yeah, again, you can challenge it, sure. The question is at two levels. One is sort of at a basic constitutional level. Do we have an emergency that gives rise to the exercise of these special powers that the government doesn't otherwise have? And on that, the courts will say, well, sure, you can challenge it, but the courts are going to be very, very indulgent to the government's decision making. And really, what you have to show almost is an irrational argument, or like we were discussing just a few moments ago, an argument of inconsistent treatment, that there's just something not consistent with the reasoning underlying the emergency declaration. Statutory, sure. I mean, you can contest whether the statutory basis for an emergency is present, but again, the statutes are drafted in a very broad manner. So I think that whether it's constitutional or statutory, one's going to have a hard time contesting an emergency. Now, at some point, I think perhaps the argument will gain strength. If the emergency declaration is in place for such a long time and it becomes apparent that, well, yeah, I mean, a lot of this is stale and that it's really being done, say, just to secure federal funding as opposed to actually protecting the health and safety of citizens, then perhaps the argument will be strengthened. But right now, the cases certainly favor the government.
This is more of an administrative type of lawyerly question that's interesting. Sometimes the dissent makes more sense than the decision. Are there opportunities to overturn bad decisions? And how does that work? How does that happen?
Well, so oftentimes the dissent will give rise to the theory that will then result in a change in precedent. And actually, a great example of that, I can point to a win that Pacific Legal Foundation had last year in the Supreme Court in a case called, and I might have even discussed this actually in my presentation last year, called Nick versus Township of Scott. The basic issue was, if you're a private property owner and you're saying that the local government is taking your property without just compensation, do you have the right to bring your suit, your constitutional suit, in federal court? And for a long time, the lower courts said, no, you don't have that right. You have to go through a lengthy state process first, a process that frankly is biased against the property owner. The Supreme Court ruled that, no, you don't have that right back in 1986. Then in 2000 or 2001, in a dissent, then Chief Justice Rehnquist, joined by two other justices, said, wait a second, this Williamson County rule, this was the case that said you can't bring your case in federal court. This doesn't make sense. And that dissent then was a green light to PLF. And over the next 18 years, I think we probably filed a dozen petitions in cases across the country asking the court to take up that issue and overrule the Williamson County precedent. And finally, in 2019, the court did take it up and ruled 5-4 that property owners do have the right to sue in federal court immediately when a local government takes their property without just compensation, and overturning the Williamson County decision from 3 decades prior. And so, yes, definitely the seeds of majority opinions can be found sometimes in dissents. Other times, they're ignored. And unfortunately, one ignoring is, again, quoting from Justice Sutherland in the Blaisdell case, the Minnesota mortgage impairment of contracts case, where a great dissent, but one that has not yet been adopted by the Supreme Court.
Okay, maybe just a couple more here. I'm curious, if there were no COVID, if we can go back just a few short months ago, what's PMF working on? What were the hot cases outside of these kinds of protections against the state? Or they're all protections against the state, or many of them are, but they're not COVID related.
Well, we have a number of what we call initiatives. These are just sort of focused efforts to overturn particular cases or to get particular policies enacted. One is called a home equity theft initiative. This is something that thankfully we don't have much of in California, but there are a number of states in the country, in particular Michigan, that if you fail for whatever reason to pay your property taxes, the state then says that your property is forfeited and you lose all equity. And so we have a client who underpaid his property tax bill by $6 and change, I think. And the local government then forfeited, said that your $70,000 residential home has been forfeited to us. And they then sold it and kept all the equity. And we have a lawsuit pending in the Michigan Supreme Court challenging that under the Constitution. And there are various abuses like that that happened in Arizona, in North or South Dakota. And so that's been a part of what we've been doing. We also still have a coastal land rights initiative, still very important, where property rights traditionally are very much under attack, frankly, are on the coastlines of the country. In California in particular, we have very significant regulation that limits private property rights. And so we have a number of cases concerning the vindication of private property rights along the coast. Plus, also a lot of what I do, although today we're talking about property rights, I do a lot of work in environmental law. Oftentimes environmental laws, although passed with good intentions, are used for improper motives and oftentimes result in the violation of private property rights. So I've been involved in a lot of endangered species and wetlands cases around the country, including here in California, trying to vindicate private property rights against government abuse.